The United States Supreme Court took something away from Donald Trump that no president had ever lost before: his ability to tax the entire planet with a phone call. But here is what most people missed in the coverage that followed. Trump did not fold. He did not retreat. He went looking for a different weapon. And he found one that is older, more powerful, harder to challenge, and wrapped in the one thing no government on earth can publicly argue against: human rights. This is not a tariff story. This is a story about a president who refuses to accept the word no, and about a legal mechanism, one that has existed since 1974, that may be about to reshape global trade more permanently than anything that came before it. Mark Carney sees exactly what is happening, and the moves he is making right now, quietly, are not the ones most Canadians are watching. On the surface, this looks like a new round of tariffs with a moral justification attached. But underneath, this is the story of how one administration, backed into a legal corner by the highest court in the land, emerged from that corner with a framework that could outlast every bilateral deal, every negotiated exemption, and every court challenge currently in motion. What I am about to show you is not on the front page of most newspapers, but it should be. If you are not subscribed yet, do it now and turn on notifications, because this story is moving fast. Hearings are already scheduled, deadlines are closing in, and what happens in the next 60 days will determine whether these tariffs become permanent or fall apart before they take effect. You need to be here from the beginning. Here is what the headlines told you. On June 2nd, 2026, the Office of the United States Trade Representative released the findings of 60 simultaneous investigations it had launched in March. The conclusion of all 60 investigations was the same. Each economy under review had failed to impose and effectively enforce a prohibition on the importation of goods produced with forced labor. The proposed remedy? Additional tariffs. 10% on countries that had at least some enforcement framework in place, 12.5% on those that had nothing at all. The 60 economies targeted together represent 99.4% of all U.S. imports. That number is not a rounding error. It means that for practical purposes, the United States just declared that virtually every country it trades with is enabling slavery. Canada is on the list. So is the European Union. So is Japan, the United Kingdom, South Korea, Australia, New Zealand. The comment period for objections closes July 6th. Public hearings are scheduled for July 7th. If the administration moves forward, new tariffs could land before the summer is out. Most coverage stopped there. An announcement, a list of countries, a moral framing, and a deadline. But here is what most coverage missed entirely. The story behind this announcement is not about forced labor. It is about a president who lost his primary tariff authority in court, had a 150-day backup plan running out of time, and needed a third legal pathway, one that could be challenged in court, but that would be far, far harder to strike down. And he found it. In a 52-year-old law that nobody in mainstream media spent a single week explaining. To understand what is really happening, you need to understand Mark Carney. Not as the politician who emerged from the Liberal Party leadership race, as the economist who has spent his entire career reading the real signals inside complex systems while everyone around him was reading the surface. Carney is not a politician who learned economics as a talking point. He guided Canada through the 2008 financial crisis with more institutional stability than almost any comparable economy achieved in that period. He was then appointed governor of the Bank of England, the first non-British citizen to hold that position in the institution's 300-year history. He spent 13 years as a managing director at Goldman Sachs. His doctorate in economics is from Oxford. This is a man who has sat in rooms where a single misread signal cost billions of dollars, who has negotiated with governments and central banks that held every card in the conversation, who understands at a level most politicians never reach that the most consequential moves are rarely the loudest ones. So when Carney said publicly on June 2nd that he was not surprised by the announcement, that the forced labor tariff was not a surprise, he was not performing calm. He had already read the room months earlier. His government has been quietly preparing new legislation to strengthen Canada's forced labor import prohibitions. That legislation is expected before Parliament rises for the summer. He knows something. And what he knows starts with understanding the legal architecture that produced this moment. To find where this story actually begins, You need to go back to April 2025, Liberation Day. The Trump administration announced sweeping tariffs on virtually every trading partner using a law called the International Emergency Economic Powers Act, IEEPA. The argument was that America's trade deficits constituted a national emergency and that the president had unilateral authority to fix that emergency with tariffs. It was bold, it was aggressive, and it worked until it didn't. For months, the tariffs held, countries negotiated, deals were struck, the global trading system was reorganized in real time around one man's executive authority. Then, on February 20th, 2026, the United States Supreme Court issued its decision in a consolidated case, Learning Resources, Inc. versus Trump. The ruling was 6-3. Chief Justice John Roberts wrote the opinion. The finding was blunt. IEEPA does not authorize the president to impose tariffs. Every tariff imposed under that authority was unlawful from the beginning. Within hours, the White House issued 3 new executive orders. 1 terminated the IEEPA tariffs. 1 reimposed a flat 10% global tariff under Section 122 of the Trade Act of 1974. Section 122 allowed the president to impose a temporary import surcharge to address balance of payments concerns. The ceiling, 15%. The time limit, 150 days. The expiration date, July 24th, 2026. So now you understand the clock. The administration had from February 20th to July 24th to find something that would last. Something with no cap, something with no expiration date, something that had already survived court challenges and had decades of legal precedent behind it. They found Section 301 of the Trade Act of 1974. Here is why this matters and why almost nobody outside of trade law circles is explaining it properly. Section 301 is not an emergency power. It is a standard trade enforcement mechanism. It has been used before, famously by the first Trump administration to impose tariffs on China over intellectual property theft. Those tariffs were challenged, they held, the Biden administration kept them, they are still in effect today. Section 301 requires a process. Open an investigation, consult with the governments involved, take public comments and testimony, issue an on-the-record determination. It is slow by emergency standards, but it is built to last. And critically, it carries no cap on tariff rates, no expiration date, no statutory time limit on duration. This is the architecture. Section 122 buys time. Section 301 builds the permanent structure. And this is where this story becomes much bigger than most people realize. Because the justification used to trigger these 60 Section 301 investigations is not trade deficits. It is not national security. It is forced labor, which means the administration has taken an issue with genuine moral weight, an issue that every democratic government in the world claims to care about, and made it the legal foundation for rebuilding the entire tariff architecture that the Supreme Court tore down. Now let us look at what the administration is actually doing, because the strategic logic here is precise and deliberate, and it is worth slowing down to understand both sides of it. The United States has had a prohibition on imports of goods produced with forced labor since 1930. Section 307 of the Tariff Act, the world's first such prohibition. It predates the United Nations, it predates the International Labor Organization conventions on forced labor. For 90 years, it sat largely dormant, enforced sporadically, quietly. Then, in 2021, Congress passed the Uyghur Forced Labor Prevention Act, establishing a rebuttable presumption that anything mined or manufactured in China's Xinjiang region was produced with forced labor unless an importer could prove otherwise. That was a genuine bipartisan human rights enforcement mechanism. The new Section 301 investigations take that logic and extend it globally. 54 of the 60 economies investigated have no legal prohibition on forced labor imports at all. The remaining 6, including Canada, Mexico, and the European Union, have prohibitions on paper, but have failed to enforce them effectively. The USTR report notes that between 2020 and 2026, Canadian authorities intercepted just 50 shipments for suspicion of forced labor. 2 were ultimately barred from entry. 2. Meanwhile, U.S. Customs and Border Protection denied entry to more than 6,300 shipments in 2024 alone under the Uyghur Forced Labor Prevention Act. That is not a minor discrepancy. There is a real problem here. Nobody serious disputes that. Forced labor is embedded in global supply chains in ways that are genuinely difficult to trace. Garment workers in Southeast Asia, fishing crews on boats that never come to port, miners in Central Africa, agricultural workers across Latin America. The International Labor Organization estimates that 28 million people globally are trapped in conditions that meet the definition of forced labor. The goods they produce flow directly into the supply chains of multinational corporations whose products sit on shelves in Toronto and Calgary and Vancouver. This is real, it is documented, and it is, by any moral accounting, unacceptable. But here is where the second open loop opens. If forced labor is the genuine concern, then why does this enforcement mechanism look exactly like the tariff architecture the Supreme Court just struck down? Why are the countries on the list the same countries? Why do the exemptions in the annex, 76 pages of carve-outs, correspond almost perfectly to things the U.S. needs and cannot replace, like crude oil and industrial chemicals, or things that would spike inflation at the grocery store, like coffee and beef? The Congressional Research Service noted that the 60 investigated economies represent 99.4% of U.S. imports. If the criterion for investigation were purely forced labor risk, that number would not be 99.4%. It would be a shorter list of countries with documented, systemic, state-sponsored labor abuse. Instead, it is every significant trading partner the United States has. The administration would argue, and does argue explicitly, that this is exactly the point, that the global supply chain is so interconnected that forced labor inputs contaminate products several steps removed from the final good. That Canada may not be using forced labor in its manufacturing, but that it may be importing components from countries that do, and that until Canada enforces a meaningful prohibition, it is complicit in the system. This argument is not frivolous. It is, in fact, the argument that scholars and human rights organizations have been making for years about how difficult it is to scrub forced labor from a global supply chain. But two things can be true simultaneously. Forced labor in global supply chains is a genuine problem. And this particular enforcement mechanism is primarily designed to rebuild tariff authority after the Supreme Court removed the previous legal foundation. The administration has not been entirely subtle about this. Brownstein-Farber's Trade Practice Group describes Section 301 as, quote, the primary vehicle for recreating the country-specific tariff burden briefly established under IEEPA, but on a more durable legal footing. Troutman Pepper Locke noted that the investigations, quote, constitute an attempt to construct a new durable tariff framework under Section 301 that can persist beyond the temporal and doctrinal constraints that now apply to emergency economic powers. Close. This is what lawyers who read the legislation are saying publicly. The strategic contrast with Trump's approach is stark. Trump governs by pressure, by spectacle, by announcement, by the tariff threat that lands at 9 a.m. and rewrites markets by noon. Carney governs by positioning, by technical preparation, by making sure that when the deal is eventually made, Canada has leverage, by getting ahead of the moral argument, announcing new forced labor legislation before the tariffs are even finalized, so that when the July 7th hearing comes, Canada is not defending inaction, it is showing progress. One of those strategies plays well on television. The other one is designed to actually work. Let us bring this home. Because for all of the legal architecture and strategic analysis, there are real people caught in the middle of this story, and they deserve to be named. In Oshawa, Ontario, the auto workers at the GM assembly plant have already lived through one round of tariff-driven uncertainty. Manufacturing has shed more than 51,800 jobs across Canada in the past year. Ontario alone lost 67,000 positions in January 2026, the single largest provincial employment decline on record. Canada's private sector shed roughly 112,000 jobs in the first 4 months of 2026. The Financial Accountability Office of Ontario has projected that if current tariff conditions hold, the province could see 119,200 fewer jobs by end of year, rising to 137,900 by 2029. These are not abstract numbers. These are the auto parts workers in Windsor who built their lives around the integrated North American supply chain. The steel workers in Hamilton, whose mill serves customers on both sides of the border. The garment sector in Montreal, which sources fabric globally and now faces the question of whether its supply chain, like so many others, has somewhere in its 12-stage production process a component that can be traced back to a country the USTR has now declared an enforcement failure. In Alberta's energy sector, the CUSMA carve-out currently protects most Canadian exports from the new tariff. Oil and gas are exempt. That exemption is not guaranteed to survive the final determination, and the CUSMA renewal itself is happening in real time, with the mandatory review deadline sitting at July 1st, 2026, 3 days before the public comment period for these new tariffs closes. These timelines are not a coincidence. In Quebec, the aerospace and defense industries have specific exposure if the annex exemptions are narrowed. Pratt & Whitney Canada, a major employer in the Montreal region, supplies aircraft engine components into global supply chains. Bombardier moves product across the Canada-US border dozens of times in a single production cycle. The complexity of their supply chains is exactly the kind of thing the new USTR report says it intends to scrutinize. And across the country, businesses that believed they had found shelter under CUSMA are now learning that CUSMA compliance is not a permanent guarantee. It is a negotiating chip. 3 scenarios, not predictions. Analytical frameworks for what the structural incentives currently support. Scenario 1, the accommodation. Canada moves quickly on forced labor legislation before Parliament rises. The new measures are substantive enough that USTR, in its final determination, grants Canada the lower 10% tariff rate rather than 12.5%, and potentially structures additional CUSMA-based exemptions into the final rule. The Section 301 tariffs go into effect in some form, but Canada's exposure is limited. The moral argument is partially neutralized because Canada is visibly acting on it. Carney's quiet preparation pays off. This is the scenario where Carney's credentialed instincts were right from the beginning. Scenario 2, the slow bleed. Section 301 tariffs are finalized but face immediate legal challenge in the U.S. Court of International Trade. A court issues a stay. Businesses operate in limbo, unable to plan, unwilling to invest. The Section 122 tariff expires July 24th, leaving a brief gap. The legal battle drags into 2027. Canada's economy, already absorbing 51,000 manufacturing job losses, continues to absorb uncertainty without absorbing clarity. Inflation stays elevated. Carney's government is squeezed between pressure from Washington and pressure from Bay Street. The CUSMA renewal stalls. This is the scenario where nobody wins quickly. Scenario 3, the permanent reset. Section 301 survives legal challenge. The tariff architecture becomes durable. No expiration, no cap, no emergency requirement. Trading partners, including Canada, are effectively required to adopt US-style forced labor enforcement regimes or pay a permanent tax for not doing so. The global trading system reorganizes around American enforcement standards rather than WTO norms. Canada adapts. But the Canada that comes out the other side is structurally dependent on alignment with US regulatory preferences in ways that go far beyond tariffs. This is the scenario where the label forced labor turns out to be exactly what it was always intended to be, not a pretext, but a permanent new architecture for US trade dominance. I'm not telling you which scenario wins. I am showing you what the structural incentives support. 3 questions, none of them answered, all of them real. 1. If Section 301 tariffs are finalized and go into effect before July 24th, does the U.S. Court of International Trade issue an immediate stay? And if it does the administration have a 4th legal pathway ready to deploy within hours, the same way it deployed Section 122 within hours of the IEEPA ruling? This administration has shown it does not wait. 2. Canada currently has CUSMA compliance as its primary shield, but CUSMA comes up for mandatory review this year. If the U.S. uses the forced labor findings as leverage in that renegotiation, as a condition of preserving the CUSMA carve-out, what does Canada have to give up to keep the exemption? And what does it mean for Canadian sovereignty over its own supply chain regulations? 3. The U.S. itself uses prison labor in ways that the International Labor Organization classifies as coercive. U.S. Customs and Border Protection enforcement of forced labor rules dropped by nearly 90% between 2024 and 2025, from $1.38 billion in detained shipments to $171 million. If forced labor enforcement is the genuine standard, when does that inconsistency become a legal vulnerability for the administration's own argument? I do not know. Nobody knows yet. Remember the image of a Supreme Court ruling arriving at 10 a.m. on a February morning in 2026, stripping the president of his most powerful tariff tool. The financial markets moved, the trade lawyers scrambled, the headlines declared that Trump's tariff agenda was dead. By noon on that same day, Section 122 was signed. By March 12th, 60 Section 301 investigations were open. By June 2nd, the findings were in. By July 24th, the Section 122 tariff expires, and the permanent structure may already be in place to replace it. The Supreme Court did not stop this tariff agenda, it redirected it into a law that is older, more procedurally sound, and wrapped in an argument that every government on earth has already agreed with, that forced labor is wrong and that trade should not reward it. That is what happens when you mistake a legal setback for a surrender. Subscribe, turn on notifications, because this story is not over, not even close. The public comment period closes July 6th. The hearings begin July 7th. The Section 122 bridge expires July 24th. The CUSMA review is happening right now. Every one of those dates matters. Every one of them could produce a development that changes what Canada pays to send its goods south. When it moves, you will want to have been here from the beginning.